Welcome to Landlord Self-Help Center's Landlord Education Series. I would like to introduce my colleagues and myself, Silvana Agostino, Alva Pereira, Carolina Rego, and myself, Diana Padierna. We are community legal workers at the Landlord Self-Help Center and will be providing today's presentation, which will address the impact Bill 184 on the N12 and N13 notices of termination. This presentation offers general information only, not legal advice. Please be aware that we will be recording this presentation, so click on accept in the pop-up. There will also be a question period at the end of the presentation. We will be answering the questions previously received, so thank you very much for sending them to our email address. Unfortunately, the chat will not be monitored. In Ontario, the Residential Tenancies Act is a provincial law that governs most residential rental agreements. It defines the rights and responsibilities of both landlords and tenants. Introduced in March 2020, Bill 184 amended the Residential Tenancies Act and other landlord-tenant laws. The bill was passed into law on July 21st, 2020, with many provisions waiting for proclamation before they take effect. The newest provisions took effect on September 1st, 2021. As part of this legal education presentation, we will discuss all the Bill 184 sections that were proclaimed on September 1st, 2021 and affect the N12 and N13 notices. If you would like to review the Residential Tenancies Act, visit the Ontario website by using the link shown in this slide. I will now pass it on to my colleague Carolina to explain information about the N12 notice of termination.
Thank you, Diana. We'll now go over the N12 notice to end your tenancy because the landlord, a purchaser, or a family member requires the rental unit. Landlord's own use means that the rental unit is required for residential use by the landlord or landlord's spouse, a child or parent of the landlord or their spouse, or a person who will provide care services to one of these individuals. A caregiver must live in the same building as the person receiving these services. Purchaser's own use means that when a unit is sold, the landlord can give a notice of termination on behalf of a purchaser if the rental unit is required for residential use by the purchaser or their spouse, a child or parent of the purchaser or their spouse, or a person who will provide care services to one of these individuals. Again, a caregiver must live in the same building as the person receiving these services. In the landlord's own use case, the landlord is required in good faith to live in the rental unit for at least 1 year. This means that the landlord cannot re-rent the rental unit or sell it. The own use notice has to be given in accordance with the rental period that the tenant has in place. So the termination date must be the last day of the rental period, which may be at the end of the fixed term, or the last day of the monthly tenancy, if rent is paid on the first day of every month. In the landlord's own use case, a notice of termination for own use cannot be given to the tenant if the landlord is a corporation. Also, the own use notice cannot be used if it is being given on behalf of extended family members, such as a brother, cousin, aunt, or grandparent. It can only be given for the individuals listed on the notice. The 1-year requirement does not apply when giving own use notice on behalf of the buyer, and the N12 can be given for purchaser's own use if the buyer is a corporation. A notice of termination for own use cannot be given to the tenant on behalf of the purchaser if the property has more than 3 units, an ineligible person is looking to move in, it's being given on behalf of individuals not listed on the notice, or there's a fixed term lease still in place. Having to pay 1 month's rent as compensation to the tenant when serving the landlord's own use notice came into effect on September 1st, 2017. A landlord must pay this compensation by the termination date on the N12, whether or not the tenant vacates the rental unit. The landlord also has the choice of offering the tenant another unit that belongs to them, as long as the tenant agrees to move into it. If the tenant refuses the offer of another rental unit, it's important for the landlord to pay the compensation by the termination date on the N12, or the application will get dismissed and the landlord will have to start all over. If you don't know whether the tenant will vacate the rental unit by the termination date, file the application with the Landlord and Tenant Board to schedule a hearing. According to Section 57, subsection 5 of the Residential Tenancies Act, a landlord is considered to give own use notice in bad faith. So it's strongly advised to consider the following before giving the N12 notice to your tenant. When did the tenant move into the unit, and is it reasonable to give notice now? Will the unit be occupied as a primary residence for at least 1 year? Is there a history of problems with the tenant? Or has another notice of termination been given to the tenant recently? The N12 notice should only be served to the tenant if an eligible person is looking to move in, they are prepared to live there for at least 1 year, and their intention is in good faith. Now I'll pass it to Silvana, who will discuss the N13.
I will now discuss the N13. Notice to end your tenancy because the landlord wants to demolish the rental unit, repair it, or convert it to another use. You can give the N13 notice to your tenant when you are planning to demolish the rental unit, when you're planning to carry out extensive renovations or repairs in the rental unit, or when you're planning to change the residential use of the unit to other than residential, for example, commercial use. The termination date on the notice must be at least 120 days after the notice is given to the tenant. Also, the termination date must be the last day of the rental period. For example, if the tenant pays on the first of the month, the termination date must be the last day of the month. If the tenancy is for a fixed term, the termination date cannot be earlier than the last day of the fixed term. For example, if you signed a 1-year lease, the termination date cannot be earlier than the last day of that 1-year period set out in the lease. N13 has to be given in good faith. When giving the N13 notice to carry out extensive renovations or repairs in the rental unit, the first thing you need to consider is that your extensive renovations or repairs must require building permits that will require vacant possession of the unit. The second thing to consider is the right of first refusal, which means that the tenant has the right to come back to the rental unit and resume the tenancy and be charged the same rent. In other words, you cannot re-rent to someone else at a higher rent. In order for the tenant to exercise their right to come back, the tenant has to give you written notice stating their intentions to come back and their address before vacating. N13 compensation. Keep in mind that compensation is also required to be paid to the tenant when given an N13 notice. The compensation amount depends on the number of rental units within the property in question. If you have 5 or more rental units, you must pay 3 months compensation. If you have less than 5 rental units, you must pay 1 month's compensation. Or you may offer another unit that is acceptable to the tenant. The unit offered must be owned by the same landlord. When giving the N13 for extensive renovations or repairs, the compensation amount depends on the time period it will take you to finish the work and how many rental units are in the building. If the tenant indicates that they intend to return to the rental unit and you have 5 or more, rental units within the same property, the tenant is entitled to up to 3 months rent. If you have less than 5 units, the tenant is entitled to up to 1 month rent. If the tenant does not intend to return to the rental unit and you have 5 or more units, you must pay the tenant 3 months rent. Less than 5 units, you must pay them 1 month's rent, or offer them another unit that is acceptable to the tenant, which must be also owned by the same landlord. Similar to the N12 compensation, the compensation has to be paid by the termination date stated in the notice, whether or not the tenant vacates. I will now pass it on to Alda.
Thank you, Silvana. Before serving an N12 or an N13 notice, make sure that you are doing it in good faith and that you truly need the rental unit for one of the legal reasons stated in the notices. Do not serve either one of these notices as a way to get rid of the tenant. Keep in mind that these notices are legal documents that have legal implications. Pursuant to the Bill 184 changes that came into effect on September 1st, 2021, landlords must now indicate in the L2 application if they have given any prior N12 notices or N13 notice in the past 2 years for the same or a different rental unit. Be mindful of the fact that if your tenant believes that you did not comply with either the N12 or the N13 notice, they can file a T5 application claiming the notice was given in bad faith. It is highly important to consider the potential legal consequences of serving an N12 or an N13 notice in bad faith. If a former tenant files a bad faith application against the landlord as a result of being served a notice of termination for the landlord's own use, the purchaser's own use, or a notice of termination for demolition, conversion, or repairs, and the tenant is successful at the landlord and tenant boards, Section 57.3 will now enable the landlord and tenant board adjudicator to order the landlord to pay general compensation of a monetary amount up to 1 year's last rent charged to the former tenant, and to pay a specified amount to the former tenant for reasonable out-of-pocket expenses, moving, storage, and other like expenses. As of September 1st, 2021, according to Section 57.12, in the case where the landlord gave the N13 notice for renovations, former tenants will now have 2 years from the date they vacated the rental unit to file a bad faith application against their former landlord if the landlord did not give them the right of first refusal under Section 53. Another Bill 184 change that came into effect on September 1st, 2021 is stated under the following section. Section 71.11. Landlords are now required to file a declaration or an affidavit along with their notice for their own use or for the own use by a purchaser. It must be filed at the same time as the application is being filed with the landlord and tenant board. This is important. If the landlord fails to file the declaration or the affidavit with the L2 application at the same time, the landlord and tenant board will then refuse to accept the application for processing. It is important to note that the landlord can choose to file a declaration or an affidavit, and that there is no preference as to which document is filed. As previously mentioned, when filling out an L2 application, landlords now have to disclose if any N12 notices or N13 notices have been given in the past. According to Section 71.13, landlords will have to disclose in their current application for own use by the landlord or the purchaser, or for demolition, conversion, or repairs, if they have previously given a notice of termination based on these reasons. They will have to disclose if any of these notices have been given to a tenant residing at the same or a different rental unit within 2 years prior to filing the current application in question. If the landlord does not disclose this information in the application, the Landlord and Tenant Board will not accept the application for processing according to subsection 4 under this section. According to section 72.3 and section 73.2, the adjudicator may consider the evidence pertaining to the landlord's or purchaser's previous use of notices of termination for on-use by the landlord by the purchaser or for demolition, conversion, or repairs in order to determine if the current notice has been given in good faith. Thank you.
It's very important to educate yourself and gather information about various topics related to renting. Use resources found on the Landlord and Tenant Board and Landlord Self-Help Center's websites to help guide you. The Landlord and Tenant Board website has links to instructions for many of their notices and applications, as well as interpretation guidelines, which provide more information about the decision process. Thank you very much for your attention. We will now address your questions. The first question says, when given an N12 own use notice, does that person moving into the rental unit have to be at the hearing? Maybe Silvana, would you like to answer that question?
Yes. Yes, the person who wishes to move into the rental unit should be present at the hearing so they can address any questions that the adjudicator or the tenant may have about their intentions to move in to the rental unit.
Thank you. The next question says, if the tenant is also causing damage and behavior issues at the rental unit, can I serve the N12 notice together with an N5 notice? Maybe Alda, would you like to answer that question, please?
Okay, sure. No, it is not a good idea for landlords to do this. As previously discussed during this presentation, landlords are presumed to give an N12 notice in bad faith. So it makes it more difficult to prove the N12 was given in good faith when there are other issues with the tenant's behavior.
Thank you, Alda. We received another question that says, I have another unit that would be perfect for the tenant, but they don't want it. They want the money instead. Can they do this? Do I still have to pay them the compensation? Carolina, would you like to answer that, please?
Sure. Yes, the tenant can refuse to accept another unit. The Residential Tenancies Act states that offering another unit has to be acceptable to the tenant. So it gives them the choice of accepting the unit that you're offering or to take the compensation instead. The next question reads, my tenant is refusing to move out by the termination date. Can I then refuse to pay them the compensation? Diana, would you like to take this one?
Yes, thank you. So that would be a no. You cannot refuse to pay it, as it is stipulated in the Residential Tenancies Act that the compensation has to be paid by the termination date on the notice. If the tenant doesn't want to move out, you will have to then file an application with the Landlord and Tenant Board and just go through the eviction process. Okay, so we have another question that says, I am serving an N12 for own use on behalf of the buyer. Can I ask the buyer to pay the compensation to my tenant? Silvana, would you like to answer that, please?
Sure. No, as the RTA states that it is the landlord's obligation to pay the compensation to the tenant, not the purchaser.
Thank you. The next question says, I found another rental unit down the street that the tenant can rent. I spoke to the other landlord and they are willing to rent my tenant their unit. Does that mean that I don't have to pay the compensation? Alda, would you like to answer that, please?
Okay. No, the unit must be owned by you, so by the landlord. Since this unit is owned by another person, the tenant is still entitled to receive the compensation for moving out of your unit.
Thank you. The next question says, I own two houses on the same street and they are across from each other. My mom is living in one and I want to use the other for a caregiver for my mom, but the tenant is refusing to leave. Should I serve the N12? Carolina, would you like to answer that question, please?
Okay. No, in this case, the N12 will not work because the caregiver would not be living in the same property as your mom. So the only way to end this tenancy, assuming the tenant in this unit is not doing anything wrong, would be to talk to them and try to get them to agree to leave. Next question says, I'm serving my tenant with the N13 because I need them to move out of the unit while I do extensive repairs. I'm in the process of getting the permits. Do I have to wait until I have permits, or can I serve the N13 now and then submit the permits with my evidence for the hearing? Diana, would you like to answer this one?
Yes. So you can serve the N13 now and note that you're in the process of getting the necessary permits in the applicable section on the actual N13 notice. It would be helpful if the landlord can include copies of the permits and other relevant documents when the landlord submits the evidence package for the actual hearing. The next question says, I served my tenant an N13 notice with a termination date of March 31st. The tenant responded by giving me an N9 notice terminating the tenancy early on December 31st and wants to use the last month's rent. Can the tenant do this? Maybe, Silvana, do you want to try that?
Yes, sure. Yes, once you serve an N13 notice, a tenant can terminate early as long as they give you at least 10 days notice on a form N9. And they can use up any last month's rent they have, or you must return it.
Okay, the next question says, can I serve an N13 notice if I need to renovate the washroom and the tenant needs to temporarily vacate the rental unit? Alda, would you like to answer that question, please?
Sure. No, you can only serve the N13 for extensive renovations that require a building permit. So in this case, if the building permit is not required, the only thing you can do is try to negotiate a plan with a tenant or try to agree to terminate the tenancy.
Okay, thank you. Another question says, how long do I have to do the renovations? Is there a particular period of time? Maybe Carolina, would you like to answer that?
Sure. So the law doesn't set a specific period of time, but you should keep the tenant informed of the progress of the works. Otherwise, they can file an application with the landlord and tenant board claiming bad faith. And the tenant would have 2 years from the date that they moved out of the rental unit in order to file this application against their former landlord.
Okay, thank you. And that's it for the question period. On behalf of the Landlord Self-Help Center, thank you so much for attending this presentation about the N12 and the N13 notices. And we look forward to seeing you in our upcoming presentations. Bye, everyone.